Hello and welcome to our webcast. I'm Amy Pendergrass with Moss Adams, and I'm going to get us started for today's session, the No Surprise Act, Part 1, Strategies to Stay Compliant. This is the first session of a two-part series with Foley and Lardner. Before we begin, I'm going to play a brief housekeeping video.
Welcome, and thanks for joining us. We're pleased to present another in our ongoing series of continuing professional education webcasts to help companies and individuals conquer challenges as they plan for what's next. Our presentation will start in a few moments. Before we begin, here are a few things to keep in mind. You can customize how you both view our presentation and interact with the presenter. For better viewing, close all other applications and turn up your speaker volume. You can also adjust window size and placement or enter full screen mode using the controls at the top of the window or dragging the bottom right-hand corner to resize. At the bottom of your screen, you'll see a series of icons, each relating to a different aspect of our session. You can download the group attendance sheet and a PDF copy of today's slides from the slide deck and handouts widget to the right of the slide view. You can ask our presenter questions during the webcast by typing a question in the Q&A window below the slide view and clicking Submit. We'll do our best to answer all questions during the presentation or follow up via email. If you experience technical difficulty during today's presentation, refresh your browser by hitting the F5 key. Today's session will offer you 1 CPE credit. To receive credit, you must meet the requirements as specified by the National Association of State Boards of Accountancy. You must attend at least 50 minutes of the session and respond to at least 75% of the polling questions, which we'll ask throughout today's presentation. To respond to a poll, click the button next to your answer. We'll track your progress and alert you when you've earned CPE credit. You can then click the certificate icon in the CPE Progress widget to open a PDF file that you can save to your computer. Don't worry if you can't download your PDF certificate today. We'll email a copy to you in 2 weeks. If you're attending this webcast in a group, you must complete our attendance sheet to receive CPE credit. The attendance sheet is available in the slide deck and handouts widget. Please have all group members sign it and send only 1 sheet per group. Also note that CPE credit can be awarded only to participants registered as themselves and isn't available to participants who view the on-demand version. As a reminder, the presentation you're about to see isn't legal, investment, or accounting advice. We encourage you to seek the counsel of a professional service provider to apply this content to your specific circumstances.
Today's webcast is eligible for CPE and CLE credits. To qualify for CLE, you will need to be logged into the console for the full duration of the program. If you are seeking CLE credit, please complete the attorney affirmation form located in the handouts window of your console. You will need to add the 5-digit CLE course code, which will be announced later on in the program. Please sign and return this form to Patrick Brennan immediately following today's program. His email is on the screen and also listed on the form. And for CPE, individual CPE credit is automatically tracked in your console. You will need to respond to at least 3 of the 4 poll questions and attend for a minimum of 50 minutes. If you have questions regarding CPE or CLE, please reach out to us via the Q&A window in your console. And now that we have all of our housekeeping items out of the way, I would like to turn it over to one of today's presenters. Kara, the floor is yours.
Hi, everyone. Good morning to those of us on the West Coast and good afternoon for the East Coast. My name is Kara Sweet. I'm an associate in the Denver office of the law firm Foley and Lardner, and I'll be the moderator of today's presentation. Allie, if you'd like to introduce yourself next.
Thanks, Kara. Hi, everyone. My name is Allie Shalom. I'm an associate and healthcare lawyer also at Foley and Lardner, but I'm over here on the East Coast in our Boston office. And I work on a number of transactional and regulatory compliance matters, including the No Surprises Act. I'll pass this over to our Moss Adams partners for today's webinar.
Thank you, Allie. My name is Lori Laubach, and I'm a partner at Moss Adams, and I'm responsible for the regulatory compliance and healthcare internal audit practice. I do reside in Washington State on the West Coast, but I work with clients across the United States. Mandy, do you want to take it next?
Thank you, Lori. My name is Mandy Mori. I'm a senior manager with Moss Adams, healthcare consulting in strategy and integration. My focus at Moss Adams is in strategic analysis, service line planning, optimization, to address service gaps, as well as to help our clients in building long-term strategic direction. I'm located in California, Sonoma County specifically. And thank you for being with us today, and I'll hand it back to Kara.
So to talk everyone through what the agenda is, it's going to be 5 parts. Part 1 is going to be the prohibition on balance billing for emergency services. Part 2 is the notice, consent, and disclosure requirements. 3 is tips and techniques, 4 is takeaways, and 5 is what's next. But before we get started, we're going to do a quick polling question. Polling question number 1 is, what is your type of entity? I'll give you a few moments to respond. To respond, please click the button next to the answer you choose and hit submit. If you can't see the submit button, please enlarge the slide area. As a reminder, if you would like to receive CPE credits for today's webcast, you will need to respond to at least 3 of the 4 polling questions.
Here, I'm going to jump in here real quick. I do see quite a few responses coming in through the Q&A window. If you do want to receive your CPE credit, you will need to respond on the slide itself so that it can track your responses. And if you don't see the poll, it's located right on your slides, and maybe try hitting F5 to refresh your screen.
So it looks like most of us today are kind of in the other bucket, but we still have a lot of hospitals who are integrated and standalone, a couple of provider groups, some health plans, but this presentation is going to be for all. So next up, I'm going to pass it to Ali to talk about kind of what are the plans outside of the NSA.
Great, thanks, Kara. So just to sort of set the stage a little bit as to what is the No Surprises Act and who does it apply to or not, and why? So generally speaking, the No Surprises Act gets to billing issues, particularly for patients, preventing surprise emergency bills and surprise out-of-network bills. It really tries to give patients the opportunity to know in advance what types of fees they're going to be responsible for. And this has been an issue for a number of types of insurance types and self-pay and uninsured patients for quite a while now, and it's something that's kind of plagued the industry going back a number of years. New York was actually the first state in 2014 to pass legislation, and since then, approximately 18 states have come out with state-level legislation on this issue. So on the federal level, this act was signed into law on December 20th, and the first set of implementing rules were released by the Biden administration on July 1st in 2021. The second set came out that fall, and the act became effective starting this year, January 1st, 2022. So plans that this does not apply to, as you can see here, it's really those federal health care programs. So for example, Medicare, Medicaid, Indian Health Services, Veteran Affairs, or TRICARE. These types of programs actually have their own separate protections baked in for their beneficiaries. So it's not that they don't receive similar types of protections, it's just they were already thought through, and they have not been running into these types of issues with their care. So this here is kind of the headliner of the No Surprises Act. If you Google it, this is one of the first things that's going to come to mind: prohibition for balance billing for emergency services. So we're going to go through some of the definitions, but this is sort of your classic example. You have an emergency, go to the emergency room, and you get a crazy bill a few months later because you didn't realize that your closest emergency department happened to be outside of your insurance network. So that's really here what this is trying to fix for patients, and really put it back on the health plans and the healthcare providers to sort out in that situation the reimbursement scheme and take it off of the patients. So who actually is a healthcare provider? a healthcare provider here is going to be a physician or another healthcare provider who's acting within the scope of practice of their license or certification under state law. Air ambulance services, which Mandy will speak about in a few slides, is actually carved out as kind of a unique and other thing within the No Surprises Act itself. And then there's a distinction here for healthcare facilities, both healthcare facilities generally and emergency facilities. So a lot of today's presentation is going to be focusing on things happening in connection with a healthcare facility. So for example, a healthcare facility is going to include a hospital, hospital outpatient department, critical access hospital, ASC, and those definitions are going to track to the Social Security Act. So as you can see here, there are a number of types of licensed healthcare facilities that are actually not listed. For example, skilled nursing facilities and things of that nature are not going to fall under the definition of a healthcare facility for the purpose of this Act. Separately, the Act also defines what an emergency facility is. So any hospital emergency department, a hospital with respect to any emergency services, regardless of where those are provided, an independent freestanding emergency department that is separate from the hospital, and which actually provides emergency services. This piece of the definition is, I just want to point out, an unlicensed urgent care center. So for example, an urgent care center that is operating as a physician medical group only, and not a licensed clinic, likely is going to fall outside of this emergency facility definition. But again, that will kind of vary a little bit by state and how urgent care centers are treated, but they don't always meet this definition. And I do see a question here about hospital-based locations. So if you for provider-based facilities, we generally are going to lump those in as kind of a hospital, part of a hospital department, outpatient hospital department, or emergency services being provided at the hospital. So generally, those will be lumped in. All right. So what are emergency services? Generally speaking, this is going to track the EMTALA definition. So as you can see here, medical screening examination within the capabilities of the emergency department, including ancillary services routinely available. So this definition will be available for your reference later. So what are ancillary services? These are, for the purpose of the No Surprises Act, these are really particular services that are going to be carved out due to the nature of, these are services that are going to be carved out a little bit aside due to the nature of the types of things that they're providing. Typically, these are not going to be the primary service that you might show up for, and you might not necessarily know whether or not these providers are in or out of network. So for example, an anesthesiologist or pathologist, radiology, neonatology. So and it doesn't matter if these services are provided by a physician or a non-physician practitioner, as long as they meet the definition of a healthcare provider. Items and services provided by assistant surgeons, hospitalists, interventionists, any diagnostic services, and items and services provided by a non-participating provider if there's no participating provider who can furnish those items or services at the facility. So we'll get into where this kind of comes into play later on. But this is generally how the No Surprises Act thinks about ancillary services to the underlying reason that a patient came for treatment. And Mandy, I will pass this over to you to talk about air and ground ambulances.
Thank you, Ali. So while air ambulance does not meet the definition of a healthcare provider, as Ali had previously mentioned, the No Surprises Act does ban surprise bills for patients who use out-of-network air ambulance emergency services, but not ground ambulances at this time. So call out 3 points here. One, the Act does require providers of air ambulance services to submit data to the Department of Health and Human Services, and the data points are quite numerous. So some of them include the data on transportation, medical costs, the data on the air ambulance bases, the aircrafts, the number of and nature of the type of transports, as well as payer data, as well as denials. And the second point, on the payer side, the Act requires the plans and the issuers to submit claims data for each air ambulance claim and transport for 2022 and 2023, which are the periods covered by the reporting requirements. So together, the information is intended to give the regulators a broad look at the industry practices and help shed some light on basically the drivers of the high cost of these services. And at the end of the day, it's supposed to inform a report that the Department of Health and Human Services, in consultation with the Department of Transportation, must prepare and make public. So while the No Surprises Act does not cover ground ambulances, the Act did require the formation of an advisory committee on ground ambulance and patient billing, aka the GAP Advisory Committee. And this committee is supposed to advise the secretaries on options to improve disclosure on charges and fees on ground ambulance services, inform consumers of options for such services, recommend best practices, and identify standards to prevent balance billing. So the Act does not cover ground ambulances at this time, but I think the future has not been written yet, and it may be very different where we stand today. So, Kara, I'm going to pass it back to you for the next polling question.
Hi, guys. We have polling question number 2, which asks, how confident are you that your organization is managing compliance with the No Surprises Act? And kind of while you guys are answering that question, just a reminder, if you guys have any questions, feel free to put them in the Q&A window. We do have a lot of content to cover today, so we may not be able to get to all of them, but we'll do our best. Good. So it looks like a lot of people are kind of in the A and B camp, that you're getting there, you're confident that you got this. Hopefully this presentation will help everyone kind of get to that A point. So next we're going to do a little bit of a discussion question. The first one I think I'm going to push to you, Mandy. When does an emergency end such that a patient can consent to be billed for an out-of-network service? And kind of how does that consent process work? Hey, Mandy, I think you're on mute.
Sorry. I'm going to give some partner with Ali, because I think this is a really good question that Ali can jump in from the legal perspective too, in terms of when an emergency is constituting to be ended. So, and Ali, so for example, like some patients, when you go to the ER, if they need specialty care and surgery, often they'll be transferred to a different hospital because it's at a higher level of care, or they require hospital admission, and the patient is then transferred from a ER directly to the floor or even the ICU. So if the patient requires services from the surgeon who's out of network, say, to have a actual elective surgery that is going to be happening down the road, not necessarily within the emergency period as maybe defined by EMTALA, in your perspective, from a legal perspective, of the definition of the emergency, and would that constitute the emergency is ended such that the patient can be billed for out-of-network services?
Sure, thanks, Mandy. So I'm going to give you kind of a very annoying lawyer answer of it depends. There are actually 4 criteria that help establish whether or not something is when an emergency can officially end. So it actually ties less to whether or not the official EMTALA emergency has ended, but also kind of goes to whether or not this patient has access to in-network services and what that looks like. And depending on the nature of the emergency, a physician might not necessarily think that the patient has the capacity to really kind of consent to those further out-of-network services, in which case you would sort of have to treat this as an emergency continuing. So the first criteria here is that the attending emergency physician or treating provider needs to decide that the patient is able to travel using non-medical transport or non-emergency medical transportation. And the facility that they would go to there needs to be a facility option within a reasonable travel distance, taking into account the individual's medical condition. So this is really an assessment of, again, that treating provider who was handling the emergency. Second, the provider or facility furnishing the post-stabilization services will need to satisfy the notice and consent criteria. So we'll talk about what this looks like later, but you're basically going to be shifting from an emergency situation where it's on your health plan to work with the healthcare facility or provider to figure out to cover your emergency services, to now it's going to be on the patient to consent to pay out of pocket for out-of-network services. Now, if the facility is in-network, this is all kind of moot. Your insurance company is going to be paying generally for all of this anyway. So third, the individual or their representative needs to be in a condition to receive the notice and consent. Again, we'll go over what that notice and consent process looks like. So it's going to be an assessment kind of based on either the tagged physician or healthcare provider, or they might need to bring in a behavioral health specialist. For example, if the individual is experiencing a mental or behavioral health episode or displaying symptoms of mental or behavioral health disorders, or consideration is also going to need to be given to whether or not the individual's condition impairs their ability to receive the information about the notice and whether or not they can even provide informed consent. Other factors that might go to this is if whatever the emergency was particularly traumatic, they might not be able to consent. So again, that goes back to the physician. And our last factor here, number 4, the provider or facility needs to satisfy any additional requirements or prohibitions under applicable state law. So I mentioned about 18 states have some type of laws on overlapping topics with the No Surprises Act. So we do need to look there as well. So if a patient is able, if your situation is able to meet these criteria, then when you get those post-stabilization services, the healthcare facility or provider can charge for out-of-network, can charge the patient for those out-of-network services out of pocket.
So, Allie, what happens, or what controls are recommended in the event someone is inadvertently balance billed?
Sure. So mistakes happen. Everyone's trying to figure this out. This is a lengthy bill. We have, 2 sessions going over all these rules, and the government has some delayed implementation, understanding there might be times that people get this wrong, especially in the beginning. So the first thing to do is stop billing them. Don't bill them anything further. Pay them back and figure out why they were balance billed. How did this happen? There are a lot of reasons this could happen, and we'll kind of go over a little bit later some of the checks and controls where things might go wrong, but you want to make sure this is a kind of a one-off, non-systemic issue. But again, stop is really the best thing. Do not send them to collections, and try to pay them back that money, and document what you're doing there.
Thanks, Allie. Next, I'm going to pass it over to Lori to kind of talk about the risks associated with balance billing.
Thank you, Kara. I think some of the things we need to think about, as we look at this act, is that we need to consider some of the things that we need to put into place that Allie was mentioning, those internal controls that mitigate that risk, and then also figure out how we're going to monitor that we've implemented it properly. And down the road, continually do internal audits of it until we feel that we have the process down and we're having less and less errors. In the initial implementation, an organization should really consider looking at where their out-of-network patients come into the organization. This helps really streamline your implementation, as well as you start to implement, like I was talking to someone the other day, they're implementing, standalone ED emergency rooms. And with that, they need to say, okay, when we do that, we've got to make sure we have the No Surprise Act taken care of during the implementation of that. It also helps you be able to determine the net results financially and the impact of that due to having to where you cannot balance bill, and now you're going to be taking the rates of their payers. And also, an organization will also want to look at the reimbursement percent as it compared to Medicare and market trends. And the reason for this is really to kind of get yourself kind of a level of where you are, where is the baseline. And then as one of the things that was noted during our discussions that we've had is that some of the payers like Blue Cross Blue Shield are starting to lower rates because they can now, they're saying, oh, if you can take it at this rate, it's the same thing when we posted all of our fee schedules online. We had a lot of payers trying to negotiate our rates down. So if you can no longer balance bill and your reimbursed by payer may also be lower, you're going to have some financial statement impact. So you'll want to take that risk into consideration when you look at your numbers and monitor that it's being done properly. And then there should be some written processes. I think there's a big risk around the process for making sure you have somebody who can contact the payers to find out who is in network, if the patient is stabilized and is able to be transferred. But you also need to make sure there's a process for being able to document that assessment of the patient if you're going to transfer them. And I think sometimes it's like who's supposed to do what when it comes to these type of situations. So you want to make sure you have a pretty good checklist or workflow so people can follow that, because immediately during training, not everybody's going to remember everything. And it's just making sure you have, we all are worried now because we all have workforce staffing issues. So how are we going to staff this? How are we going to make sure we have the right things in place to hard stop things so they don't go out incorrectly and we bill patients when they shouldn't be billed? So that limitations or constraints can really cause a risk to our organization. I'm going to hand it back to you, Kara.
Thanks, Lori. Kind of going to our next discussion question, I'm going to ask Ali and Mandy, when do these requirements apply to non-healthcare facility-based providers, such as physician groups?
Sure. So generally speaking, there are a lot of situations where physician groups may have relationships with facilities, with licensed healthcare facilities where they're providing services. So in those situations, if they're providing, for example, you have an outside physician group providing services at a hospital, such as like an outside anesthesia group or telemedicine or other kind of specialty, they are now going to sort of be bound by the requirements that healthcare facility would be and needs to coordinate on the requirements in the No Surprises Act.
Yeah, I'll add on, just to expand on Ali's example. So, for example, a non-healthcare facility-based provider, such as, like I said, an out-of-network gynecologist or any other specialist, they can be credentialed, but they're not affiliated, with the in-network facility providing, say, in this case, a non-emergency hysterectomy. So the patient can be asked through, basically the process to be balance bill, and we'll address the notice and consent process in a bit. And the other thing that would just come up with, what about covering hospitalists? So whether it's covering hospitalists or intensivists, critical care physician, if they are basically those two categories, the patient is limited to his or her healthcare in-network cost-sharing amount. So these providers cannot balance bill patients, and the patients cannot be asked to give up their federal protections not to be balance billed.
Thank you, Mandy. Going to kind of discussion question number 3, which I'm going to go back to you, Mandy, on this one. Do these requirements apply if a patient was transported by emergency air ambulance providers and transferred to a ground ambulance for transporting to an emergency room?
Thanks, Kara. So earlier on, we talked about just the application of the No Surprises Act to emergency air ambulance providers. And balance bill does prohibit out-of-network emergency air ambulance providers to balance bill patient, right? So the answer is yes for the first part of the question. As it relates to ground ambulance, the answer is it depends. So in the absence of federal laws, state and governments locally, they play varying roles in this aspect. Many states do specifically prohibit balance billing from ground ambulance providers to patients. So the caveat is that some of these state regulations only apply to like a subset of ground ambulance agencies. So one example is, say, in Maryland. So a patient is being picked up from one county, say Howard County, by a county-operated ground ambulance company and transported to basically an ER in Maryland, Baltimore County. So as a non-resident being picked up from one county, transferred to another county, Baltimore County, the patient does get an out-of-network bill because the protection only applies to patients of the county of Baltimore, as an example. Then another state, for example, in Colorado, you have a car accident that's in a remote area of Colorado. Patients get airlifted by a ground ambulance that's operated by publicly funded fire departments, which is very, very common, to be transported to an ER. And the patient will get an out-of-network bill. But conversely, if the patient is actually in Colorado being transported by a ground ambulance that's operated privately to be transported to the ER, the out-of-network private ground ambulance is prohibited to balance bill patient. They're instead reimbursed at 325% of Medicare payment rates. And so the patients are then limited to pay out of pocket to only the in-network rate. So the exceptions in this case do apply depending on the ownership of the ambulance companies and also what state it is actually occurring.
Thanks, Mandy. That was very helpful. Next, we're going to go into if there are any exceptions to this. Mandy?
I'm sorry, go ahead. Oh, yeah, the exceptions basically apply depending on the state and where it is actually occurring. So again, different states have different protections when it comes to balance billing for ground ambulance as well. So even though it is not currently covered by the No Surprises Act, it depends on where this is actually occurring and depending on what state. So in the absence of the federal law, the state basically, if the state law covers the ground ambulance prohibition to balance with the patient, then the state law applies. But again, this is not applicable in every single state. And again, depending on the agency's ownership, whether it's actually a publicly funded, is a county operated, is a private operated ambulance company.
Thanks, Mandy. We're going to the next kind of part of the presentation, which is notice, consent, and disclosure requirements for non-participating providers to bill patients. Before we get there, we're going to go to our polling question number 3, which is how many forms are there related to No Surprises Act balance billing? Choices are 1, 2, 3, 4, and unsure. Okay, we got a lot of people that are unsure here, which is great. I'll pass it off to Allie to kind of talk about what is a visit and then to talk about kind of how many forms are required.
Sure, thanks, Kara. So I'm going to do some level setting of definitions for this second part. So I was hinting quite a few times earlier that there are ways to kind of bill patients for out-of-network services if you do certain things. So this section is going to kind of talk about what those all are. So one thing that I think can get a little lost in this section of the No Surprises Act is what actually is a visit. The definition is here, but what I do want to highlight is this actually includes items and services furnished kind of pre and post the actual physical visit or what you might think of. So there could be imaging before or after, telemedicine component, lab services, and these are sort of all going to be encompassed into what we define as a visit for which the patient is going to need to provide notice and consent in order to be balance billed. Now I will point out this, so now this is the situation where a non-government beneficiary patient with health insurance is going to a healthcare facility that actually does not that is not contracted with their health plan, in which case it's considered out of network. So in this situation, the healthcare facility or healthcare provider has to follow these obligations in order to charge the patient out of pocket. So what do they have to do? There are actually 3 different forms that need to be provided to these patients. So the first is a notice form, basically telling the patient that the healthcare provider is a non-participating provider, give a general estimate of what the charges may be of the items and services involved with their visit, and again, you can read the items here. We highly recommend using for all of these forms CMS's templates. It's a little hard to sort of get around their templates, so we really do recommend that people utilize those, and that way you hit all of the buckets of things that you need to actually tell the patient in order to appropriately bill them. Separately, then the patient has to consign a consent form. It confirms that they did get the notice, and the patient has been informed of that charge, and that they agree to be treated by the non-participating provider, and they may be balance billed for that. And then they also need to, in one of the auditing things that I do want to point out here is you want to make sure they have the date and time when they received these forms. So if they're being mailed, you want to be tracking sort of all of these details. And then third is a disclosure form. So this is going to be a 1-page form, can be double-sided, no font smaller than 12 print. You also need to post it on the website and hang it in any prominent public locations at the healthcare facility as applicable. This sort of needs to explain what the No Surprises Act is, any state corollary requirements, and how, if something goes awry, who the patient should be contacting on both the state and federal level. Again, there is a form from CMS, a template disclosure form to be, for your use.
So again, there's some different risk areas we need to think about. There's a lot of information that Ali just shared, but I always, first time I read it, I thought there was just 2, and having 3 definitely makes a difference because it all says the word notices or consent, and it all sounds the same as you start to work with your team. But we're thinking right now, 1 more notice to provide, right? 1 more consent to have to do. And it's really important, and one of the biggest risks is if you do, when you do implement this, that you use that content that the CMS is providing, because it's just key to get all that elements and that information across to the patient. And you need to make sure it's easy to provide. So as Ali was mentioning, there's option to mail. You can also email it to the patient, but you do have to think about how you're going to track how you did that. Also, an organization must think about having somebody who can explain that notice to the actual patient. It's important that they be able to understand it, and maybe not legally understand it, but understand that this is what the content of it is. As you sit and think of yourself as a patient and hearing about this the first time. We also, one of the things that I think is interesting to get into the actual act is it has to be available in 15 most common languages. It's not like in some other situations where it's based on the top, certain number of languages. It's 15 common languages, so you have to determine that. And then it's all really challenging to post notices. I have gone and done walkthroughs of various emergency departments and unable to find the charity care notice to other types of things, related to the patient's notifications. So I just recommend that you, think about walking through after this has been implemented and months later looking to see. You also need to make sure it's on the website and it's easy to find. Many times we'll go in and try to find information like this and you search, and they're not going to know the words No Surprise Act. They're not going to know the word good faith estimate. So think about how you can post it so it's easy for a consumer to find it and actually know where it is. It could be a button just on the front page. I don't know, that's probably too easy, but just do that. And then also thinking during the workflow for the provision of the notice that you think about, what's going to happen during that typical admission or check-in and having controls that is provided to, it needs to be insured to all insured patients regardless of network status. at some of the language out there, but you need to make sure you have controls to make sure that this gets to those patients and it's for each episode of care. Since the Act does not require that you have documentation of how you provided the notice, you need to think about how you're going to be able to provide evidence that you did provide it, right? So it's that normal due diligence that you need to think through as you start to implement this. And one of the things that is interesting about the consent is the patient could waive the consent for non-emergency services, but they need to revoke it in writing before the item or service is provided. But those are for non-emergency services. Any additional thoughts, Allie, on these items?
No, Lori, I think that was really helpful. I did just want to address a question or two that I was seeing here in the chat. One was about those CMS forms. There'll be links at the end of the presentation to those forms to help you find those. I just wanted to point that out there.
Great, thanks.
Let's get into another discussion question. And maybe we'll go over kind of specific examples here. So when are these services considered part of a visit such that they require kind of the notice, consent, and disclosure? Maybe the first one we talk about is telemedicine.
Sure. So again, as we sort of defined visit, it's not necessarily just when the individual is at the official appointment. It may include a pre or post-op visit of some kind. For example, if the patient's ultimately having a surgery and has a telemed connected consult to that, it may be roped in, even though telemedicine is not actually at a healthcare facility itself.
How about kind of like respiratory therapy and physical therapy? Maybe Mandy, you want to address that one?
Sure. I think this is also going back to, really importantly, the definition of a visit, as we went through that earlier on in a couple of slides before. So again, depends. Unfortunately, the answer is kind of gray, and I know it's not always the most popular option to say depends, but it does. So it depends on whether the services are provided in connection to that visit that is defined by the Act. So as an example, again, respiratory versus physical therapy. So if a patient is receiving respiratory therapy in connection to a visit that is part of the definition of the Act, then the requirement of the notice, consent, disclosure will be necessary. And if it's, again, the other part about it that we also have to think through is, again, if the patient is receiving services at an in-network facility, right, participating facility. So that will change basically the answer to some of these questions. So if it's a non-participating facility providing the services is not connected to the visit, then notice, consent, disclosure is not necessary in that case. So, and next thing, like, for example, wound care, right, Kara? So wound care, one of the things about wound care that's unique is that wound care, like a lot of services too, can be freestanding versus in-network hospital-based facility services, like an outpatient wound care department. So in a freestanding wound care clinic, and again, depending on whether the definition of the visit is met, the requirement for the notice, consent, disclosure may not be necessary, but the letter will be considered if it's part of like hospital outpatient services, the letter could be considered a non-emergency services at an in-network facility and may fall within the definition of a visit, and thus will require the notice, consent, and disclosure. So similarly, when you look at cardiology, if you're looking at cardiology, a patient goes to a cardiology office, right? It could be independent cardiologist not associated with a hospital outpatient department, or it could be a hospital outpatient department. If it's an in-network participating facility, and again meets the definition of a visit, the actual visit itself, the E&M, basically the evaluation and management, as well as the tests performed, if they meet the definition of visit, then the notice, consent, and disclosure would be required. Ali,
And
what are
Mandy,
your
just to
thoughts on
tack, and just to tack on to that a little bit, one of the questions I'm sort of seeing here in the chat, in those E&M sort of visit options, in that notice, in the consent forms, you want to include, like for cardiology, what do you generally think is within the scope of what would be expected for this patient, and list kind of these options that might end up, that are routinely covered in this type of visit. It's a little more legwork, of course, on the end when you're scheduling. But if you're ranking kind of patients on, okay, this person is presenting these symptoms, what generally do we think would be covered in their cardiac workup? That's something that would be should be in the notice. If it's a completely unexpected treatment, then that's going to be handled a little bit separately. But in that notice for the visit, again, they want you to list kind of expected services to really prepare the patient for what they're going to be responsible for out of pocket.
Thanks, Ali. Thanks, Mandy. Going into discussion question 2, let's talk about some of the operational concerns related to the 3 forms. And maybe, Lori, for this one, who is responsible for providing the forms?
I think everybody, as we were telling about it during our discussion, is responsible for this. It's not just the front desk of the clinic or the emergency admission department or folks that are standing there in the line of fire, but it's really about everybody. But it's making sure that we have controls in place that, that like when we first started with the HIPAA notice of privacy practices, it prompted us to make sure that we did that. It was part of the packet. It was part of the information that is provided to the patient on each episode of care. In case of HIPAA, it was not every episode of care, but it was really making sure you had a control in place. It's also, thinking about whether or not you have a manual process you're going to have to do because your system can't automate it. And so I think some of the things I worry about in an operational perspective is if I have to rely on, making sure the packets are correct, it can end up getting missed in the process. And so just really having that as the step process that you go through.
And Lori, can I just mention like something, or go ahead, Ali.
Sorry, yeah, in regards to also who's responsible providing the form, sort of 2 other little points here. To the extent that there is a facility and a separate entity provider group providing services at a healthcare facility, we recommend doing some level of coordination, making sure they're talking. You don't want to over-inform the patient with 2 or 3 different sets of these forms. So kind of at this, if you haven't already done this, communicate with the either corresponding facility or provider group and maybe even put in writing who's going to be responsible for collecting this information and providing it to patients. That will prevent kind of confusion down the line and extra clarity for the patient. Also, with respect to who needs to provide these forms, back to that ancillary services definition that we talked about kind of a while back, a lot of those services might actually be already kind of lumped in, but we do recommend kind of itemizing everything out, again, that's going to be expected. So again, on the facility and provider.
So what happens, like mistakes happen. So what happens if a form is missed or it's misreported or mismarked? What do we do in those situations?
I think we have to think about one of the things that is that the enforcement right now is been delayed. It doesn't mean that later on if somebody will come back and audit because a patient complains about a bill being balance billed, but it really does important that you have some controls in place or some monitoring to see what the integrity of your staff related to the services. So if they miss a form and misrecord or mismark, then they need to, considering that depending upon the form, is make sure that they get that corrected into the patient. I don't know if you want to add anything else, Ali, on this other than just do not balance bill. But Ali, any additional items on that?
Yeah, I mean, again, don't balance bill. Just stop that finance team. Stop any collection efforts, things like that.
Yeah. Okay.
So then, guys, what happens if a patient cannot provide consent? What do we do in those situations?
Sure. So in this situation, if a patient is unable to provide consent. Sometimes that may be because they're a minor, or they may have a condition that prevents them to. So this is really going to be treated as kind of, in my opinion, an informed consent situation. So how would you go about getting informed consent for a general, for a healthcare procedure, for example? So is there a designated person who can provide that on their behalf? So someone really still does need to fill out and sign before you can balance bill. You just need to identify who the best and appropriate person in this situation is to provide that consent.
And look at your other.
If there is no one,
yeah. I was going to say, if you have other consent, if you can't get
consent, then you can't bill.
Yeah, and I was just going to say, just try to follow your other consent processes you have in place as well, and some of the scripts related to that as well. I think one of the biggest challenges we're going to have here is the patients that are going to challenge the bills. And if we, and the other one, there's two big issues. One, and that is one, and the other one is we accidentally send them to collections. And so we really have to have controls in place to prevent that from happening. And so whatever you can put into your billing system is the best way to do it, and make sure that you have a lot of training of all of the staff in that process.
Okay. Thanks, guys. Now, Allie and Lori's already given us some tips and tricks for operations and auditing, but I think we can have a little bit more. So Lori, can you give us some more tips and techniques?
Yeah, I think what I've seen the best in various organizations is where they have a nice workflow, that's in a graphical perspective that's available to the team to be able to understand not only what they need to do, yes or no's, but also what the implications are if they don't do that step of it. And not implication you're going to get fired, but more of just this is an implication to the organization as a whole from a compliance perspective. So make sure that we have some training for all employees throughout the organization, not just the folks that are at the admissions desk or the folks, I mean, they're probably going to have more technical training, or the folks in the balance in your revenue cycle, but it's really making sure that you have training for them on what to do and who to go to if they have questions. And then whatever happens when you get that patient says, you're not supposed to balance bill me, and how do you answer that question on that? And then I think really looking at your current software to see if there's a way that it can assist you determine what the patient's insurance is as they show up at your desk as they schedule a procedure. Make sure that it's a very strong software that understands. I've had some of those out there that actually will tell me what I had 10 years ago, not what my current program is. And then I think having it have those type of flags, or I call them edits, or ideally work queues that tells me this person is a patient who cannot be balance billed. And that then tells my revenue cycle folks that I cannot send them to collection. I need to make sure that patient statements are not even an option. And just make sure. And, there are, it's just having some way to run reports to say these are all the out-of-network patients we've had, and this is we didn't balance bill them, et cetera. So I think documenting that and completing reviews of the claims. So some tips and techniques. So some steps on how to audit a No Surprise Act. It's kind of one of those things where you have to really first figure out how we implemented this within the organization. And that's how you would then complete your internal audit of it. But you're also going to need those policies, procedures, and also those protocols. We rely heavily on training as well. So sometimes you can't get everything written in through your policy committee in time. So make sure that you have all that material that you use to try to roll it out. And then look at the workflow changes that have occurred in all the different areas that apply to the No Surprise Act, as well as the type of internal controls. And so I think determining how you're going to monitor those internal controls by, are we going to have reports? Are we going to have work queues? We're going to have those type of things in place. So what was put in place, so then you could go back and audit if those actually got triggered, and if they didn't get triggered, why did that happen? Move on to the next area. Kara.
Yeah, so the next one is our last polling question. what do you guys think is your biggest gap to become compliant with the No Surprises Act? We've got a couple of options: patients, providers and clinicians, the patient access department, revenue cycle, staffing constraints and shortages, finance, or just even all of the above.
And while everybody's checking the box, I'm going to talk a little bit about internal auditing, and because that's my favorite topic. But I think one of the things is, in your doing the internal audit, you might want to start with looking at all the required documents to, pull a sample, see if the patient received all the documents to ensure that they're compliant, determine if the notice has been posted prominently, and then also then take that and say, okay, can I tell in the chart or in the electronic health record or wherever it's being stored that they received the notice, did they get the consent? And then what were the steps to determine the patient's responsibility, as well as trace the communication and document of any estimates or information provided to the patient.
Thanks for that, Lori. It looks like all of the above, maybe a little bit of a gap to compliance, with a second of kind of the staffing constraints and shortages. Allie, could you give us some takeaways?
Sure. Just sort of looking at some of the chat questions. Just to sort of clarify, there are kind of two primary scenarios that we've been talking about. One is just a flat-out prohibition on billing patients for emergency services that are out of network, and the second is the notice, consent, and disclosure process in order to be able to bill patients who do have health insurance that's not government insurance, how to bill them if they're looking to receive out-of-network services and pay for that out of pocket. So just sort of to clarify there. And I also do see a quick question. These forms cannot be combined. CMS has separate individual sheets of paper for each of the notice, consent, and disclosure there. So takeaways, kind of really echoing what Lori said earlier, just about those your technology resources. You want and your overall internal systems. Check what the industry is doing. Make sure you have a process in place and that you're reviewing whatever that process is. Having a checklist is really helpful. If it's not working, think about what isn't working and why and how to change it. And make sure that you have good technology to allow for nimble responses to these. As I mentioned earlier, there is some delayed enforcement on the No Surprises Act. And the government is continuing to have open forum calls and come out with clarification and guidance on a pretty regular basis. And we do expect some more information is going to be coming out this summer. Some of the calls, they're sort of really just taking down questions and seeing where the gaps are in this bill and what information needs to be provided. Lastly, one thing that we didn't really talk too much about here, but there is kind of a dispute resolution process between health plans and the emergency providers for that out-of-network situation where you can't bill the patient, for the provider and the health plan to come up with a rate that will be charged for those out-of-network services.
And then, Allie, I'm just going to do a quick interruption to give the CLE code. It is 58XNC, and I will push it to the audience, too, so you can see it on the screen.
There's a question about whether CMS has examples of all required forms, and there are links at the end of this webinar that have the links to all the required forms by CMS, where I think this is where it's advanced to right now. So that's the link that you can click on. It does have examples of all required forms, the standard forms.
And we'll be reviewing the questions that we did not answer and providing input back to the individuals after this presentation. And I think the last thing is please sign up for our next part. It'll be on the GFE estimate. So we have a lot of examples we're going to go through, so be prepared to get your pencil out.
And just so you guys know, if you have registered for this part of the webinar, you're automatically registered for the second part. So we look forward to seeing you then. And this presentation can be downloaded directly from your council if you want access to any of these links, additional resources that we have provided. Thank you guys all for attending us today and spending kind of your lunch break with us. We really appreciate it and look forward to talking to you guys next week.